my lady. I think I've ever started after lunch without saying there's quite a lot to be getting through, but there is a little bit to be getting through.
Yep.
So,
Appreciate that.
the tort defence, I'm on the reach and scope of it. I took you earlier to the indication, or the indications, or the flavour that one got from Nissan about quite how that might be analysed, in particular in the context of military operations, and I think I took you to the relevant parts in Lord Pearson. Can I just invite you briefly to go back to that, just to get the flavours or indications, particularly in the context of military operations that one might get from Nissan. The passage I placed particular reliance upon was Lord Pearson at 910728. And it's perhaps worth adding into that little section, dealing with the sorts of things that probably would be within the conception, with its reference to in any fighting or any urgent military necessity, but again, not trying to define the universe, just simply giving those as examples. And he gives us the paradigm examples of act of state without attempting a definition. If you go back to a place earlier in his judgment, when he's defining those things from which the remoteness of these facts was to be judged, at 9105 at the letter F. Necessary to consider what is meant, even if it's not expedient to attempt a definition. It's an exercise of sovereign power. Obvious examples are the making of war and peace, and so on.
Yes.
So there we've got the making of war and peace. And then Lord Morris, sorry to jump around, but Lord Morris, in a passage which is quite often cited but incompletely in the judgments below, 9088, between B and C.
Yep.
And the passage which is cited without completing it, as it were, between B and C is the bit about it being the Burren and Denman principle being too well recognised now to be overthrown, which it might be thought is the very issue which you're thinking about now. But if you see the next sentence, that's of some interest in terms of the flavour that I'm on. I'm referring to times of peace and to times not affected by sudden emergencies. So his rareness, his hope that it will be rare, which effectively is the punchline of all his dubitante, does it really apply here, and it's not giving a remedy when a wrong's been committed and all of that. Increasingly rare, he says, but then he's specifically cutting out from that. I'm referring to times of peace and to times not affected by sudden emergencies.
He's referring to armed conflict.
Yes, in contrast to peace.
Yes, and I think it's right to say that all the illustrations in the case law are in a context of armed conflict, not necessarily international.
Yes, and that for our purposes is all we need, as it were. And so you get those flavours from the judgments in Nissan. Lord Reed, may just be worth very briefly looking at Lord Reed in Burma Oil. I know I was concerned with a different issue. You'll be very familiar with the facts of Burma Oil, but Burma Oil is in bundle 2 at tab 15, starting at MS 9533. And here, as you will recall, he's exploring the scope of the royal prerogative. Remember all the references in non-justiciability in McNair, for example, we looked at earlier about royal prerogative and time of war and matters of that kind, times of armed conflict. On the same sort of theme in Burma Oil, where they're considering the scope of the prerogative, taking property without compensation, query. Between F and G on page 9558. Lord Reed says, so the prerogative certainly covers doing all those things in an emergency which are necessary for the conduct of war. to those sorts of flavours, the flavour from Lord Morris and the flavour from Lord Reed in Burma Oil and the flavour from Lord Pearson rather more expressly in the context of Nissan, they're all very much to the same end, we respectfully submit, which is that they are focusing on the special rules, the special prerogative application in times of armed conflict. And my Lord Wilson alighted on urgent military necessity, particularly in the Lord Pearson extract, but the adjective, it might be thought, isn't at the centre of the doctrine or the principle we submit. So that is a helpful indication of the sort of territory that is of interest and the sort of flavour that one gets both from Nissan and from Burma, decided a few years before it, 5 or 6 years before it. And I emphasise that although, of course, it is right for this court to explore, as we were doing before the short adjournment, the limits of the principle, how it applies, how it should be set up and all of that, in the end, the common law method is to do things incrementally by reference to the facts that are before you. And for that purpose, all I need here, whether or not it extends to drone strikes or whether or not it extends to some other sort of sovereign act that one might be able to envisage, and whether or not, if they'd ratified in relation to the hotel in Cyprus, maybe one thing or another thing, it may be susceptible of argument. But Lord Wilberforce, as you will recall in Nissan, was very concerned when he was dealing with the two conceptions specifically to emphasise that he wasn't attempting a full-blown, comprehensive, cover-all definition. He was describing the concept and allowing the common law to develop it by reference to the facts of particular cases which provide, it might be thought, the appropriate place in which the principle could be either developed or constrained. So one can envisage a whole raft of situations which might lead the court to pull in the horns of the doctrine or to expand it to cover necessary things. But for present purposes, I only need a principle, and I only need to espouse a principle which has the following particular elements. Firstly, we submit trying to identify the characteristics of the sort of thing that would engage the doctrine, and I emphasise engage the doctrine whether you view it as a defence to a tort claim or an immunity or non-justiciability understood in the sense of the court declining to exercise its jurisdiction. The key features we submit are that the Act represents what could properly be characterised as a sovereign act. Lord Pearson, you will recall at 9105F, described it, he said it's an exercise of sovereign power. And again, without going back to it, the Kamachi case, the one about annexation of the Raja's territory, that is absolutely full on repeated emphasis on the exercise of sovereign powers. Secondly, it's got to be in the conduct of foreign relations. It doesn't apply to sovereign acts in the UK.
Those are two separate things you've just said. Conduct of foreign relations and doesn't apply to sovereign acts in the UK.
Well, right, 2 and 3 perhaps.
So outside the United Kingdom.
Outside the United Kingdom. Fourthly, and perhaps rather more fluidly, it must have the nature required to qualify as an act of state. That is a deliberately looser concept. But the boundaries are not hard set, we respectfully submit. The court in Nissan identified things that paradigmatically were within that, including the making of war and peace, concluding treaties, annexations. And it may be helpful in particular cases to identify or analyse how far or how close you are removed from those sorts of areas. That was the nature of the approach in Nissan.
This is really a subset of A, isn't it, or at least an elaboration of A, i.e. a sovereign act.
Sovereign act for this purpose.
It's got to be a particular, by which we mean.
Yeah.
Yes. Kamachi is a good example of that.
Kamachi is a good example of that, and that's why I took you to those references both in Burma Oil and in Nissan, where the court had been considering what might or might not fall within that sort of territory.
But are you going to try and encapsulate what you mean by, after all, you say the nature required of an active state, and you give the examples of war and peace, concluding treaties, annexations, or one could call it conquest, and annexations. But what we're concerned with is none of those things. It's the conduct of military operations.
Which
You
I
want to
respect.
add those?
My lady, I do, and those are, I respectfully submit, included in the light reference to war in those earlier authorities.
Oh, I thought war and peace was concluding war and peace, not conducting war, because it's definitely not conducting peace.
Well, it's making war. It's operating an armed conflict.
War, right. So,
That's why I took you to Lord Reed in Burma Oil.
so
Kamachi didn't involve any military activity at all.
It didn't.
well, that was annexation, wasn't it?
That was annexation. I mean, the most that one can say is that it's pretty clear that the application of force would have followed if they hadn't submitted to the inevitable.
Yes, but it's an example outside war, so it extends beyond that. But for my purpose, all I need is to explore, for the purpose of this case, what things that are to do with the pursuit of armed conflict would fall within that sort of act. And I respectfully submit that whatever else it may be would plainly include, and that's why I took you to Reed in Burma Oil, Lord Reed in Burma Oil, all those things necessary for the pursuit of military operations. And so that would include lethal force. It would include detention on imperative grounds or for imperative reasons of security.
Well, can we tie this into any international law concepts of matters which would be dealt with at an interstate level, matters where complaints would be dealt with if there were any at an interstate level? I mean, can we tie it into anything like that? Either considerations linked to the Geneva Conventions or
My Lord, we can, and I'm going to come to that,
Yes.
because when I come to the justification for that reach and scope, because at the core of my submission on justification is going to be that this is particularly suitable and apt for regulation at the level of international law, as opposed to having to justify the legality of those acts by the United Kingdom in the pursuit of, say, armed conflict or military operations abroad by reference to local municipal law.
Have our common law colleagues wrestled with this defence?
They haven't, the researches that we've conducted, in particular focusing on the United States, the closest we've come in relation to that, which I'll come to when I come to deal with the justification, in a case called Malachy and Gates, involved the question of whether or not, of course it's always complicated by local legislation, but it involved the question as to whether or not an individual who was detained in Bagram could maintain a habeas challenge before the US courts. And they considered that the answer to that question was no, because it might cut across, goes to the one voice principle, it might cut the separation of powers principle, it might cut across the effective pursuit of those military operations abroad. As I say, one needs to be a bit careful there because it's A, habeas, and B, local US legislation, and they were seeing whether the suspension clause applied and so on. But that's the closest we respect.
Thank you.
There is a question, if one is seeking to try to capture the essence of the characteristics that would lead to the defence, if I can use that word compendiously, being triggered, there is some question about the extent to which you needed to have a policy element to the decision.
Yes, because Lord Reed deals with that when considering the Halsbury definition, doesn't he?
Yes, and there is some suggestion that it's got to be a deliberate part of the policy.
Yeah.
And one can see that the deliberate part of that it might be thought pretty obvious, otherwise it wouldn't be properly characterised as a sovereign act. But the extent to which it needs to engage issues of policy...
Deliberate on whose part? Because in Buron and Denman, the only deliberate act was that of Captain Denman. And it became an act of the Crown simply by virtue of ratification. You couldn't say that it was the policy of HM government before ratification
to burn the barracoons.
To exceed the powers conferred on them by the treaty.
That point made by Lord Reid at 908 AC.
But that's why I raised this last, to put question marks over both elements, as it were, both the deliberate nature. It might be argued that in relation to the deliberate nature of it, there's a distinction between ratification on the one hand and prior authorisation on the other.
Well, on the face of it, the ratification is what identifies the relevant policy.
We will call this in and call it our own.
Yes.
Yeah. Well, quite. I mean, I think the reason for focusing on the policy side of things is because the Court of Appeal, it was quite a strong strand in the reasoning of the Court of Appeal, the decision whether or not, for example, to detain Mr. Sardar Mohammed was too remote from high-level policy decision-making to qualify. And so for that reason, they said, this defence was not triggered. But that, we respectfully submit, is a difficult line of reasoning in this context. It's difficult because the decision as to whether or not to detain for imperative reasons of security is critical here. And it is, in essence, that policy, if one's focusing on detention, which is in play, so as to render the state's detaining activities subject to international law rather than municipal local law, or subject to their own policy that you need to detain people for longer than local law might allow. You will recall from the earlier Sardar argument that the facts in his case were, if Mr. Justice Leggett is right about the content of Afghan law, that you could only detain people in an armed conflict for a period under local law of 72 hours. Forget about all the debate about 96 hours and the UN policy and so on, but under local Afghan law, it's 72 hours and then you're out. And so the question is, if one's looking at this in terms of high-level policy decision-making, is the United Kingdom prepared to commit, as it were, troops into as hostile an environment as Afghanistan or Iraq, on the basis that they might be subject to a requirement under local law, which they couldn't escape from whatever their policy was, that you had to release people after 72 hours or 24 hours?
Well, at some point you're no doubt going to say what, if any, limits there are. You've emphasised local law there, but there's at least one case, Maya Evans, is it, where conduct in Afghanistan was assessed by reference to domestic policy and principles. And just taking your habeas corpus example, what if Mr. Sardar Mohammed had issued a habeas corpus in the UK during his detention period?
Yes. Well, my lord, my answer to that is going to be, and I'm going to come to it under the one-voice justification, because the way in which the Court of Appeal dealt with the one-voice justification was to say, how does that work? How does that sound in circumstances where you can get into court on a similar-looking issue, such as through habeas or through JR or through the Human Rights Act claim for damages under Article 5? And a large chunk of the answer to that, you won't be surprised to hear, is going to be that under none of those systems does your detaining activity get subjected to the vicissitudes of local law.
I see. So the distinction, that's the distinction, is it?
Well, it's a part of the distinction.
Yeah.
It's an important strand. Can I come to? I'll come to that.
The basic rationale is that the UK forces, when they go abroad, can take with them British law and can be expected to act in accordance with that, is it, but not in accordance with local law.
That's a big strand of the justification, exactly so. And I mean, to some extent we know that if you're in detention in an armed conflict of this kind abroad, there's been a battle royal in the courts here and in Strasbourg about what system of law is appropriate to govern that, what should be the lex specialis in principle, effectively. And we know that under our law currently, even if one looks at it under ECHR, you've got Hassan and the United Kingdom dragging in international law as a standard, providing you with a basis for detention. So that sits in contrast, as it were, when one's judging one voice in the context of a private law claim for damages. That sits in contrast, in very stark contrast, with the idea that you subject yourself, as it were, to the local legal regime, which may be, and we would submit if Mr. Justice Leggett is right on Afghan law, in the context of Afghanistan plainly is, entirely unsuitable for the purpose. You simply cannot have a system which requires you under local law to release a Taliban commander after 72 hours if you've got nowhere to release him to and he still needs to be detained. That simply is completely inappropriate, whereas the other systems of law are more forgiving. But I come to the justification of the tort defence, if I may, or this conception of it. The principle, if upheld, I emphasise, would operate to preclude a claim in tort if the act in question satisfied the sort of conditions I've just gone through. And that would mean, the principal effect of that would be that you wouldn't have to justify the legality of the act under the foreign municipal law. That would be effectively irrelevant. And the justification for that is, we respectfully submit, one voice or separation of powers. And we agree respectfully with the way in which Mr. Justice Leggett put that. We've quoted the relevant part of how he put that justification in our case, if I can take it from there without going back to his judgment for this purpose. Our case at paragraph 56 on MS 12-195. It's not the business of the English courts to enforce against the UK state rights of foreign nationals arising under foreign law for acts done on the authority of the UK government abroad, where to do so would undercut the policy of the executive arm of the UK state in conducting foreign military operations. That's from his Sardar Mohammed judgment at paragraph 395, and he quoted it again, or arrived at the same conclusion in Ramatura at 182. That's our case, paragraph 56. That the one-voice principle is clearly established in general is evident, and I'm not going to go to them now, but is evident from the authorities we cite at paragraphs 58 and 59 of our case.
Which page, sorry?
Sorry, page 12196.
Thank you so much.
Or 12195. I started with the way in which Mr. Justice Leggett expressed it.
Yes, I see. Thank you.
In paragraph 56.
Yep.
I mean, how far does the one voice principle carry anyone? I mean, all it amounts to saying is that in some areas you accept what the executive has done, but that's not a general principle of law. Otherwise, we wouldn't have much business in this court.
Well, how far the justification flows may be a different matter. That it is a general and well-recognised principle is evident from the authorities we cite at paragraphs 58 and 59, but whether one casts it as one voice or separation of powers, or the court's deliberately deciding that there are certain acts which shouldn't have to be done.
I mean, it is simply an assertion of what you're aiming to get at, because it doesn't tell you when you speak with one voice, does it? So it just recognises that there are, in this area, some situations when it's important that the two should speak with one voice.
Yes, although it does to some extent give you an indication of when. If one goes to, if one acknowledges that that principle includes, as at least a part of its underpinning when the state is engaging in military operations abroad, not, if I can put it in the way the American cases have, giving succour to the enemy and creating a situation whereby people can come here and claim damages in tort with the potential for the money to flow back into the continuing armed conflict. All of that, those are themes that the American courts have perhaps explored more fully than ours. But they do indicate a real practical punch potentially with one voice. Of course, it doesn't directly answer the question when should they speak with one voice, but it does indicate that if you're dealing with a claim for damages, you're creating, as it were, a private law right to claim money from the state for doing that which it judges is entirely necessary for the proper conduct of serious and important military operations abroad. Now, how far one goes down the route of explaining that and justifying it in terms of the real practical punch of the thing, one can have an argument about. But if you still have open those passages on the case, in our case that I just took you to, and you cast your eye to the facing page, 12197,
Yes.
you will see the way in which the Colombian District Court of Appeals in Macaulay and Gates put the matter. Yeah.
Yes.
Sorry,
Yes.
I misquoted it. That is a citation.
That's a citation from the US Supreme Court in
Eisenhower.
Eisenhower.
Yeah, exactly so.
This is aid and comfort to the enemy point. Eh?
Yeah. And that was to do with the
Undermining war effort, really.
undermining war effort. And there are various ways in which one can see it undermining the war effort. I mean, there it was a pretty extreme example because it was cutting out habeas altogether. So they've gone pretty far down the line in protecting executive action in military operations abroad. Perhaps it might be thought further than we would do here. But the underlying principle remains the same. And if you're looking at a claim for damages in tort, the undermining of the war effort is not so, I mean, it can be cast at a variety of different levels. You can say the UK government, which is the proper, under our separation of powers, body under our constitutional settlement for prosecuting those military operations, has concluded that you need to detain for 2 months, 3 months. That's necessary in order to protect our soldiers, to protect the local civilian population, to fulfill the UN mission. Then someone comes here and claims under local law, because that's the way the conflict choice of law rules bounce, and subject that authorised and deliberate UK policy decision to a totally different legal standard, which requires Mr. Mohammed to be released after 72 hours. That's one way in which it's not speaking with one voice. Secondly, you could say, well, it's a right for damages that is thereby created in the face of an authorization of that kind, and so the money can flow back into the continuing armed conflict if necessary. And the third and perhaps general way is to say it's completely inconsistent to say you have a UK authorized detention judged to be necessary for one purpose, they should be detained for 3 months, and yet, by operation of a common law cause of action and the choice of law rules that are attached to it, you end up with Afghan law being the governing law and Sardar Mohammed being released with the IED dust, no doubt still fresh upon him, after 72 hours or back onto the battlefield. So there are a variety of really serious practical ways in which that separation of powers or one voice principle applies. The Court of Appeal, and it's the point I think my Lord Mance raised with me, the Court of Appeal were very troubled by the idea that there might be nothing left of one voice or separation of powers in circumstances where one could end up, the domestic court could end up looking at similar looking issues, as it were, through a variety of different routes. So they focused particularly on the possibility of judicial review applying, and they focused on the existence and availability of the HRA claims, which we do not say Crown Act of State operates to cut out.
Yeah.
There's a general point in answer to that, which I might start with, which is that the fact that domestic law might examine some matters for some purposes doesn't, we respectfully submit, as a matter of logical principle, justify a conclusion that domestic law or some foreign system of law should examine all matters for all purposes. There may be a particular reason for examining a particular set of issues, and there may be a particular justification for courts entering into the areas that they do. There isn't, therefore, any necessary logic or principle basis for saying you should jump from one place to the other. So you should jump from JR to saying, yes, you can have a claimant has a right for damages judged by reference to local law as well. Focusing on judicial review, first of all, and for a moment, if I may, the fact that judicial review is or may be in the field doesn't remove, we respectfully submit, the one voice or separation of powers justification. Judicial review is not concerned with affording a financial remedy to persons at all. It's concerned with securing the rule of law by subjecting the actions of government domestically as government to the legal standards that public law sets. And once one has done that, once that purpose has happened, the constitutional logic is spent. There's no real attraction, we submit in principle, in turning what we say is a virtue of our legal system, namely JR, driven by the rule of law, into a justification, therefore, for an expansion so that you create a cause of action, a right for damages, which may be governed by a foreign law. In any event, at the stage when the court is reviewing the legality of a policy, the defendant is properly the executive here, and such review is permissible. So the court was able to review, for example, the legality of the policy to a challenge direct technique, a particular form of interrogation technique. Went to the Court of Appeal in a case called Hussein, and in the context of Meyer Evans, the case my Lord Mance referred to, there what was being challenged was the legality of the policy. So the Secretary of State have said, I've got a policy that I won't transfer people where there's a real risk that they might be subjected to ill treatment at that stage, and still it's controversial whether the ECHR might apply, but the Secretary of State said, I've got that policy. And what was being done was to test prospectively the question of whether or not, if they were to transfer in particular circumstances, that would engage that principle. There's nothing inconsistent with that. That doesn't undermine or suddenly lead you to the proposition that you therefore need a claim for damages, or that justifies a claim for damages as of right applying the foreign law. Nor does it touch the question of what would happen when the act is authorised by the executive and is then implemented. So there are those differences and real important distinctions we submit between JR and the private law claim for damages. We also know, as a general matter, that the public law principles do not exert the same sort of control or type of control over the conduct of military operations of this kind as might be imposed by private law actions. And that is in two respects. Firstly, and in any event, because it narrows the gap, as it were, public law principles themselves recognise that there are forbidden areas, to use the language from Abassi, or no-go areas. So even in public law, there will be real restraint exercised by the court. Secondly, and perhaps most importantly, they don't drag in local law. You couldn't turn up on a JR or a habeas application or anything of that kind in these domestic courts, assume that Serdar challenged his detention when he was still detained by UK forces, and say, right now, judge that by reference to Afghan local law. So we respectfully submit that judicial review is a virtue and not a vice in this respect. It, if anything, underpins the proportionality of taking a narrow approach to private law causes of actions with all the choice of law that is implicit in those. And you can't reason from the logic that a court could look at those sorts of issues in a JR, which are different in any event to the issues that arise in a private law action. You can't reason from one to the other to say, well, because you look at it you look at some parts of it, some different aspects of it in a judicial review, there's no longer any justification for the tort defence or for the court imposing a jurisdictional limit upon itself. And nor, we respectfully submit, do either of the two other cases that the Court of Appeal referred to for this purpose. They referred first of all to Meyer Evans. They also referred to two other cases, one World Development Movement and two Burma Oil. I'm not going to go through all those orally, but we respectfully submit that for the reasons we've set out in some detail in our case, those are very different. And they don't in any sense, once one understands what the issues were in those cases, they don't in any sense support the idea, some general idea, that the moment judicial review can look at some particular part of executive decision-making, there should therefore, as it were, as the logical consequence of that, be an undermining of the justification that says one voice or appropriate separation of powers. Our case in that respect is all in paragraph 65. It's World Development Movement and Burma Oil. We dealt with those in some detail there, and I won't spend time orally on those.
Understand.
So JR is one thing that was said to undermine the one voice justification for the tort defence, and we respectfully disagree with that. Then it was said, well, the Human Rights Act is now in the field, so that removes any concern about any of this. And means that the court can impose or can allow and should allow these sorts of tort claims to proceed. But we respectfully submit that the Human Rights Act plainly doesn't undermine the one voice justification or the separation of powers point. It represents a specific statutory intervention in the field, and the common law, including Crown Act of State, has always been subject to statutory intervention. That's why we're no longer resisting HRA claims on the basis of Crown Act of State. But in any event, and more broadly, the fact that the HRA may be in play through the guise of Article 5 and the possibility of a claim for damages under Article 5 does not lead to the conclusion that it's in effect open private law damages claim season for all matters to do with the legality of the detention. And that is for the obvious reason that nothing in the Human Rights Act purported to sweep away, as it were, Crown Act of State or anything of that kind. We know from the parallel context.
But how does the defence operate if one does have a claim for breach of Article 5?
Well,
say I've been unlawfully detained. I have my rights under Article 5.
Yeah.
I'm entitled to compensation and relief.
Yeah.
And now how, if at all, can you deploy the defence? You can't.
You can't deploy the defence under Article 5. But the reason that or the other reason that.
So why isn't that good enough for the claimant? It isn't good enough for the claimant because what, the damage, you don't get much damages under Article 5 or what?
Well, it's because judged by the system of law that is applicable under Article 5, and this is the stuff of the debate in other aspects of Serdar, we say that Article 5 has not been breached. But that illustrates a very important point in terms of the distinction between an HRA claim and a private law claim for damages, which goes quite close to the heart of the reason why one voice is not undermined. If you look at the HRA claim, if you're Serdar Mohammed and you come and claim HRA damages, what has traditionally been done in the past is to say, and this was the stuff of the last hearing we had on Serdar, is to say you haven't got a power under Article 5, and there is now some Article 5 case law in Strasbourg that says, even though Article 5 does not include the ability to, expressly does not include the ability to detain under Article 5.1, there's no ground that says in a military operation you can detain a Taliban commander or anything like that. Argue about the analogies with other grounds, but there's nothing that says that. But so the Strasbourg court in a case called Hassan has said, in the context of international armed conflict, no, but you can drag in a justification in principle, even though it's not expressed in Article 5.1. There is power to detain, and the power to detain is derived either from international law, e.g. the Geneva Conventions or international humanitarian law, or from the UNSCR's, United Nations Security Council resolutions. It said you had to do everything that was necessary, you could do everything that was necessary to pursue the mission that the UN had given to the United Kingdom, amongst others. And so what that demonstrates is that your Article 5 claim, now through the door marked Hassan, drags in as the justification for detention international legal principles that might be thought to be the lex specialis here anyway. In other words, international humanitarian law and or the UNSCR. What you do when you introduce the private law claim for damages, by contrast to the HRA claim, is to do exactly what they've done here, which is to say, we don't need to bother about that. The only thing we need to demonstrate to get a right to damages is to launch the claim here, assert that our detention was unlawful under Afghan law, apply the choice of law rules that says everything happened in Afghanistan, there's no reason to disapply them, and therefore it's Afghan law that governs. Afghan law, if Mr. Justice Leggett is right, and it's subject to appeal, but assume he is, Afghan law says release after 72 hours. And this man couldn't be. He couldn't be because he was being interrogated, and he couldn't be because at the time there was no capacity in the Afghan system to take him. So the consequence under Afghan law would be that he'd have to be released. And what that illustrates is that by not allowing the tort defence to run, as it were, you end up or risk ending up in a place where something as absolutely critical as being able to detain on a continuing basis for as long as was necessary for reasons of security, your ability to detain the Taliban commander disappears or risks disappearing because you subject it to what we respectfully submit is a fundamentally unsuitable local legal regime. And so far as the HRA is concerned, far from undermining the one voice principle, it is positively illustrative of the justification of the one voice principle, because what you are doing is allowing the policy to take effect, as it were. Now, there may or may not be differences between Article 5 and all the arguments are run through and the UK policy. There may be arguments about the extent of UN authority versus UK policy and all of that. But the fundamental difference between the two is that under the one system, Article 5, you get international law coming in through that route, whereas under private law, you risk not doing so.
And under private law, how does what you just referred to as the defence slot into the principle that we're referred to Afghan law? It's not a defence under Afghan law, that's one thing. It's clearly a very specific English law defence. Is it a defence or is it a procedural bar?
Well, it's a procedural, yes. It's something that all the courts below have recognised would apply, as it were, here and not be dictated by...
Or is it, there are two ways it could come in. It could come in as a procedural bar, which may be important.
Or a jurisdictional point.
Or it might be a jurisdictional or a public policy point, which overrides, yeah.
A bit of that. One needs to be a bit careful with that. I'm going to come to public policy because you'll remember that the Court of Appeal placed a lot of weight on that in their redesigned principle. The public policy...
Well, they had a public policy qualification to something which is perhaps a public policy rule.
Quite. And also a public policy exception on their conception of it,
yes,
which effectively focused, a bit like Oppenheimer and that line of cases, on whether there was something wrong or contrary to public policy, almost ad legem, about the foreign law.
Yes.
Whereas ours is a much more generalised question. Should you be subjecting... And in a way, it's counterintuitive, but should you be subjecting this sort of action to that legal standard? And so it's not a question of demonstrating that the local law is in some way peculiar to local law unsuitable. It's just unsuitable to have it governed by local law at all.
If you submit, as I understand you do, that this is a substantive rule, a substantive defence, then you have to bring that, do you not, within the public policy exception to PILA in section 14.
Well, if you treat it in that way, as opposed to treating it as a jurisdictional point or...
Well, that would be procedural.
Yeah.
But I understand it to be critical to your case, and certainly critical, for instance, to your argument that Article 6 isn't engaged, that this is a substantive rule. It can only be a substantive rule if Afghan law is for certain purposes rejected and reference made to English law instead, and that would have to be justified under Section 14.2 of the 95 Act, wouldn't it?
Yes, although one needs to be a little careful. You'll remember I took you last time, and I may or may not have time to go to it again today, but I took you last time in the context of foreign act of state to a case called Markovic. Do you remember Markovic?
Yes.
About the bombing of and acts of the Italian government and so on? And they treated that effectively as being a jurisdictional matter, and therefore as...
Well, it was a substantive lack of jurisdiction.
Yeah, exactly. And so one doesn't necessarily need to treat it as though it was akin to something that had to be crammed into the local foreign law. So I don't necessarily, I mean, again, it may just turn around to labels and quite how one ends up describing it, but I don't necessarily accept that you'd have to drag it within the public policy exception. In any event, my submission is going to be that even if the Court of Appeal was right to say that's the analogue and you've got to in some way get it within that public policy exception, that just takes you back to the same argument, takes you back to the same question, but asks what the nature and conception of the public policy is. And as I say, our respectful submission is that the fundamental flaw in the approach of the Court of Appeal was to focus on seeing whether there was some ghastliness peculiar to the local law, as in Oppenheim and Catamol, and dispossessing a particular segment of the population of their property wholly discriminatorily, as compared to the broader question of public policy which we say arises, which is in this sphere, is it appropriate to subject these sorts of acts in the pursuit of military operations to the exigencies of local law? That's in essence how we put it.
So you very helpfully, I'm so sorry.
No, Karen.
You very helpfully answered Lord Clark's question about, now look, the claimants have got their Article 5.1 Human Rights Act point.
Yes.
What more do they get out of the tort case? And you've explained that. I mean, there's this enormous case under Article 5.1 that we've all got to wrestle with.
Yes.
It does seem odd, act of state or no act of state, that having had that enormous issue, were they to fail on that, it does seem odd that they can simply redirect themselves on really the same point, detention, into another area of law.
My Lord, we respectfully agree, but we say it goes even further than that for the reason I indicated, which is that what they're doing is not to take the same issue and repackage it. They're fundamentally asking the court under this private law claim for damages to judge the legality of those actions, not by the HRA standard, which incorporates through Hassan international law, but to subject it to the vicissitudes, as we would submit, they are properly
you've explained that.
of Afghan law. But we agree with the sentiment, if I may respectfully say so. And to some extent, that international legal aspect in the context of military operations, armed conflict of this kind, that international legal aspect is another strand of justification. So one's got one voice floating around, one's got separation of powers, which is the right body to prosecute this, and one doesn't want to be subjecting the authorised detention to some local law regime which might be wholly unsuitable and is in our case. But inherent in that is, well, where's the legal standard? What's the legal protection? And one's always alive to the need not to leave, as it were, a legal vacuum. But here there isn't a legal vacuum, precisely because the HRA exists, and precisely because the relevant system of law by which these actions should be judged is international legal standards.
And how does the principle in Oppenheimer and Catamol, which you mentioned a few minutes ago, the jus cogens, or as it's sometimes put, how does that fit into this analysis? Suppose you were being tortured.
Yeah.
The claimant was being tortured, and he was complaining about torture. What would be the position then?
Well, my Lord, we don't assert that Crown Act of State could justify that sort of activity.
Even if ratified.
Even if ratified.
Why not?
Because it wouldn't be properly characterised as a sovereign act. It wouldn't be properly characterised as part of government policy.
What if it was?
Well, then we would be prepared to accept, as it were, the oversight of the court in that.
That depends on what's meant by a sovereign act.
The oversight of the court.
Oh.
We are not saying that there was a dispute, you'll recall, in Nissan, particularly between Lord Reed and the rest of their lordships, or at least some of their other lordships, about whether or not if the government were to say it is act of state, that would be that. Lord Reed's analysis was if they were to say that it is act of state, he had difficulty seeing why it wouldn't be act of state. But some of their other lordships were rather more careful about that. As I say, we are not shutting the door. It perhaps takes us back to the debate we were having before the short adjournment. We are not shutting the door on the fact that the court is involved in this exercise. Indeed, we pray that in aid, if we get to the Article 6 proportionality stage, we pray in aid the narrowness of the doctrine. But we pray in aid the fact that... I'm sorry, my lord.
Unless you're in a position to identify some principle on which the court is to act, it's very difficult to see what is the coherent framework which justifies the existence of this doctrine. I mean, you seek to avoid the notion that it's simply a matter for judicial assessment on a case-by-case basis. But unless you can provide a framework of principle to determine on what other basis the court is to decide it, how else do they do it?
Well, the court is involved on a case-by-case basis in the sense that on the characteristics that I've outlined, sovereign act of a particular nature that, as it were, falls within royal prerogative, the court is involved in assessing whether or not the act in question has those qualities, is of those qualities. So the court is involved on a case-by-case basis at that stage. That is not to throw the doctrine open so that it becomes, as it were, unprincipled and subject solely to judicial discretionary decision-making in any particular case. And for example, I would not accept that these judgments, as it were, about whether or not it was militarily necessary for the sake of argument. Suppose one had go and bomb the hill or attack that particular encampment or building. Those, it might be thought, would be properly matters on which the court would defer unless there was some jolly good reason not to, like bad faith, public law standards applying, to the judgment of the executive. So there are plenty of tools for the courts to use which would allow the doctrine to be principled because it has the characteristics I've identified, but not, as it were, to be a principle which is undermined because it is solely dependent upon the ipse dixit of the executive. There is a middle way, in my respectful submission.
You tied this common law defence a moment ago by analogy or in parallel with the defence which you suggest exists to an Article 5 claim by reference to international law. Well, couldn't we look, in answer to the problems that have just been raised, to the legitimacy of the conduct under international law? I mean, it's suggested that we should tie it down to circumstances, if we accept the doctrine at all. Your opponent suggests we should tie it to circumstances where the UK is obliged to act in a particular way under international law, but assume that one doesn't go that far. One could at least say that this defence of Crown Act of State can only exist if the UK is acting consistently, either with the general body of international law or at least with what counts as jus cogens in international law. What do you say about that?
My lord, entirely content with that. Entirely content with those. I mean, that's exactly those sort of constraints that would be dragged in anyway entirely properly, without, as it were, rendering it pure judicial discretion and without rendering it pure executive decision.
Yeah.
Somewhere between the two exists the middle ground, and the middle ground, it might be thought, are things like the principles of public law or the principles not being inconsistent with the principles of international law, which we respectfully...
Would the principles of public law, for example, include the requirement to act rationally?
Yes. So if you said, I'm going to bomb that place over there, and I'm going to bomb it because I think that's necessary for the purpose of military necessity, and you knew full well that it was a children's home.
I mean, the only trouble about that is that Buren and Denman, in the light of Sir William Scott's rather controversial earlier decision about the legitimacy of slavery, does seem to have proceeded on the basis that there must have been a breach of international law.
There must have been a breach of international law because
Well,
it went
it
beyond...
can hardly be in accordance with international law to go and destroy private property in somebody else's state.
When not authorised by treaty.
When not authorised by a treaty.
and then saying, it's okay, I can...
And I mean, Sir William Scott's decision, I read, was should have been challenged, actually, by the 1830s or 40s. That's the argument that Amanda Perrine-Sosin, I think, develops. But leave that aside. The actual basis seems to have been... Anyway.
I mean, it may be explicable on the basis that it's a strange and muddly case, because although it may be a breach of international law to do that, there are reasons for doing that. It would hardly be a breach of jus cogens if the reason you were doing it was to free people from slavery, even if that hadn't quite developed to the point of being something which the international community regarded as such a... I mean, so I can see the arguments, but those sorts of principles can be developed, but it does mean that there are...
So deliberately bombing a hospital would be one thing. I see that. Yeah. But suppose it wasn't a deliberate bombing case, but a case where it was just irrational, not involving any kind of moral turpitude of the kind deliberately bombing a hospital would have, but something which would be held in public law to be an irrational act. You would say, what would you say? You say, it's all part of the war, or what?
Well, I suspect that the answer to that is it isn't, if you're looking at it from a public law perspective, you are already in territory where the courts would have to make judgments of exactly that kind. I mean, we know that in public law, leave aside Article 2 and all the principles that it's dragged in, the courts have traditionally been extraordinarily reluctant to second-guess military judgments. And it may be that operates not to exclude the principle of irrationality operating, but to impose, as it were, a super threshold upon it. But I think if you were in territory where, I mean, I can live for the purpose of this argument with the development of those principles as a species of control.
There must be certain things which the Crown cannot lawfully authorise or ratify.
Yes.
If it purported to authorise or ratify, e.g. torture, which is the easiest and most extreme case, one wouldn't expect the courts to have any difficulty in saying that that was devoid of legal effect because it was beyond their powers. When one turns to other areas, like the rationality of bombing Hill 1 rather than Hill 3, it's a bit more difficult.
It can be a bit more difficult, but in the end, the question that my Lord keeps probing, and I quite understand why, is, are there tools which would enable one to occupy the middle ground between pure judicial discretion and therefore unprincipled on the one hand, and on the other hand, pure ipsi dixit and therefore thoroughly unattractive of the executive on the other? And the answer to that is yes. We may not be able to precisely formulate all of them now, but the principles of public law and international law give one plenty of weapons in that sphere. Quite how any particular principle might apply in any particular context can be a matter to be thrashed out.
One principle would be that the courts would not recognise the power of the Crown in dealing with foreign states to use certain methods, such as torture.
Because that would be, but again, that comes back rather to the sort of point that my Lord Mance was making. I mean, the existence of a jus cogens.
That's the relevance of the jus cogens.
Exactly.
It doesn't make it any easier to solve the bombing of a children's home.
It may not do, and that may have to be developed, but it doesn't mean, which is really what this argument is going to, it doesn't mean that the principle of jurisdictional constraint / defence is unsound because it cannot be said to be principled, which is perhaps all I need. I think somewhere in that line of questioning, there was a point was raised about obligation.
Yes,
and
that's the Respondents' case.
Right, that is a point of some importance, both on the Respondents' case and because the Court of Appeal were interested in obligation and teed it up in that way. But my respectful submission is that also doesn't work properly in this context. If I'm right up to this point of the analysis, the elements that I've identified do not, or indicate that this is not a doctrine which is dependent upon the existence of an international legal obligation to do something. The focus is rather on whether this is something which the courts should properly leave to the executive rather than subjecting it to the ordinary rules of tortious damages claims. And it is that is the critical feature. It can't turn on whether or not you're obliged to do something, and it can't turn on that because, as you recall, the only reason that everyone got sucked into that debate about obligation versus authorization was because it was thought that Article 5 in the Al Jeddah litigation did not include within paragraph 1 any justification for detaining Mr. Mohammed or his equivalent, Mr. Al Jeddah, in the Iraqi context. And so the search was on, as it were, for some way in which the obviously necessary detention could be justified. And the route that was argued for in the Al Jeddah litigation domestically and succeeded before the House of Lords was, well, you don't need to worry about Article 5 because Article 5 is entirely displaced because of the operation of Article 103 of the UN Charter, which has superior force. So when the UN Security Council says, here's your mission, do what is necessary for imperative reasons of security, that must include detention, and that trumps Article 5. But that's now all gone by the board. We've gone well beyond that in the context of Hassan, because Hassan now allows, impliedly, for this sort of detention within Article 5, even though not expressly mentioned. So it's, as it were, entirely adventitious that obligation versus authorization is still lurking around as an interesting thought. But this doctrine cannot depend upon whether or not the word in a United Nations Security Council said authorized, circumstances where they couldn't compel the states to contribute troops anyway, as compared to obliged. This is about whether or not one system of law or another should govern. This is about whether or not the Executive Act should be subjected to the vicissitudes of local law, and whether or not this is a sort of act that, under the separation of powers, should be left to the executive. And that's got absolutely nothing to do with obligation versus authorization. If the United Nations Security Council, let's assume, says, go into Afghanistan, we authorize, brackets, but then they say expressly, but do not oblige you to detain people, and you can detain people on imperative grounds of security, what difference would that make to the argument? You would still have thoroughgoing authority under international law. That would justify the detention under Article 5 for Hassan purposes, and yet it would be said that you could still bring a private law claim for damages and subject it to the vicissitudes of Afghan law. And the only reason that that is so is because the UN Security Council resolution did not say obliged, it said authorized. We respectfully submit, therefore, there's a complete disconnect between the focus on obligation on the one hand and the existence and grounding for this doctrine on the other.
Do we have Hassan in the bundles?
I'm not sure you do in these bundles, I have to say. They're certainly in the Serdar bundle. I'm so sorry, we rather assumed that we were going to get the same lot, but you're a new edition.
We've got quite enough here, probably.
You have. We can certainly give you Hassan. It's probably short. And I was going to take you to Mr. Justice Underhill in Al Jeddah, if I may, very briefly on this point. He's in Bundle 1, Tab 4, 9112 in the electronics, and the relevant paragraphs for this purpose are 76 and 77. But he's quite interesting on this point about obligation, is why I go here. Although he was proceeding on the basis that there was an obligation, because he was still subject to Al Jeddah in the House of Lords, as it were, he nevertheless reasoned as he did in 76 and 77. Yeah. This was, of course, in Iraq, as you'll recall. So we respectfully submit that obligation doesn't work as a necessary precondition to the application of the Crown Act of State doctrine. The other feature that the Court of Appeal were concerned about was the idea that and to some extent one gets a little flavour from Lord Morris as well, in fairness to them, but the idea that this excuses a wrong, this doctrine of Crown Act of State operates to excuse a wrong, and there should always be a remedy where there's been a wrong, to which it might be thought the realist says, as wherever there's a remedy, there's a right. One can cast that anyway, which way you want in principle, but the question is, does it actually excuse a wrong? Does that operate to provide some driving force for a very limited conception of the doctrine of the kind the Court of Appeal espoused? And we respectfully submit not. Not firstly because those sorts of concerns that it might be thought to operate to exclude a wrong and therefore should be kept narrow, particularly in the speech of Lord Morris, if you recall that in Nissan, they did not lead to the conclusion that there should not be the Crown Act of State principle, that it shouldn't exist. Lord Morris's punchline, if I can put it that way, was to say it is to be hoped that this will be relied upon and used rarely. And that's the significance of the omitted sentence that immediately follows that statement, it should be used rarely, which, as you'll recall when I took you back to it a little while back, said, but I cut out from that times of war or other urgent emergencies.
It doesn't excuse a wrong. You say it creates an overriding right.
Yes. Yes, quite. But it doesn't on any view, it didn't on any view lead in Nissan to them saying the doctrine shouldn't exist, and it didn't lead to them saying it shouldn't exist and operate with full force in the context of war or military operations. So that's the first answer. And the second answer, perhaps, is that, I mean, on one view it excuses a wrong if you apply ordinary choice of law rules, because you're assuming that the wrong has been committed by reference to the legal standards created by the local foreign municipal law. Here, Sardar Mohammed has not been released after 72 hours, as is required, if Mr. Justice Leggett is right, by Afghan local law. But that simply begs the question. And the fact of the matter is that the local law happened and happens to be known in relation to Afghan law, because Mr. Justice Leggett's had a look at it. It happened to be known in Burren and Denman, which is why they could tell that the slaves could be possessed under the local law of Galenus. But as a general matter, Crown Act of State operates as an in limine point, which in effect operates to excuse the state from having to justify the legality of its act by reference to local municipal law. And so it is, as a principle or as a defence or as a jurisdictional constraint, it isn't dependent in any shape or form on knowing what the local law even is, let alone whether it's been breached so as to create a wrong. So you can't reason that you create a wrong because you're not complying with local law, and that drives the conclusion that this doctrine can't operate. So we respectfully don't accept the idea that there is driving force for a narrow conception of this doctrine because it can be taken to excuse a wrong. We just say that's question begging. So just before coming to the Court of Appeal conception of the doctrine, the public policy doctrine, I've already made the submissions, but just to remind you, the crossover with the defence of tort, how these doctrines hang together, it is evident, we submit, that there is a real question around whether there are some acts which should provide either a defence to a claim or an immunity to the claim or a narrowing of the court's jurisdiction. It doesn't matter, we say, how you approach that, how you characterise that. The question is ultimately the same. And it's ultimately the same because it is the court deciding what the characteristics are, what the principles should be, what the nature of the doctrine should be. And it doesn't terribly matter what label you put on it. The effect is the same. It is to cut out, shut down, in limine, a foreign or a claim for damages of this kind. And we submit that if you view the doctrine in that way, and you also recognise that there are some elements of non-justiciability strictu sensu, in other words, things that are inherently unsuitable within it, but that's a separate category, then you end up in a place, leaving those aside, i.e. inherent unsuitability decisions aside, should we declare war, should we annex the territory, where you just haven't got the judicial weaponry or tools competently to decide those questions. If you leave those on one side, you reach a position where the two conceptions of the single doctrine by Lord Wilberforce are not, as it were, hermetically sealed. And it's perhaps entirely unsurprising that that should be so. Lord Wilberforce's analysis, as you will recall, started with the quotation from Wade, which, as it were, spanned the two conceptions, then effectively said, this is a description and not an exhaustive definition, then said, and the doctrine can be developed from case to case, and so I'm just giving you the shape of it, and then went into his two conceptions. But it's entirely unsurprising, viewed in that way, that the conceptions are aspects of a single doctrine, and that the critical question outside justiciability strictu sensu, the conceptions of it don't terribly matter. What matters is the court prepared to say that there are certain acts which should lead to the shutting down in limine of that sort of claim for damages, should lead the court to conclude that it isn't appropriate to subject those sorts of decisions to the usual private international law choice of law rules that would otherwise apply, and therefore to subject things like detention in Afghanistan to the vicissitudes of local law. And if the answer to that is yes, there are acts of that kind, and that's been long recognised by the courts, however fluid its initial genesis or conception might have been in Burren and Denman, then the only question for you is what are the characteristics, what are the features of the act that should attract that protection? And I've been through that. Can I turn briefly then to the Court of Appeal's conception of the doctrine and the way in which ultimately the Court of Appeal disposed of the matter? And they put very considerable emphasis on public policy, and then took a very, very narrow view of what public policy would justify the operation of this sort of defence. They, in effect, reinvented the doctrine so that it became a doctrine which was squarely and narrowly focused on trying to identify some sort of Oppenheimer and Catamol vice in the local law, so as, in effect, to equiparate it with Section 14.3 and so on. And the first point, therefore, is that they do appear to have approached it, that public policy idea, on the basis that the court should be looking for something intrinsic and specific to the foreign law, impacting on the public interest. And we respectfully submit that can't be the right approach in this context. If the doctrine is to operate at all, it does so on the basis of the nature and character, not of the foreign law itself, but of the sovereign act in question. That's the focus of the doctrine. That's its drive and justification, if it works at all. And if that is the base conception of the principle, as Nissan suggests it is, then this form of control, public policy focus on a vice inherent in the local foreign law, introduces something which is both unnecessary and unrelated to the base conception of the principle. And so we say the conception of the doctrine is to avoid a particular species of act from being subjected to any system of foreign local law. Its purpose and aim is not to enable the courts to differentiate between, if I can put it this way, good and bad foreign legal systems or rules. Secondly, we say that the principle of Crown Act of State as we espouse it is shaped and is narrow in the way that I've indicated, precisely because of the public interest. So the public interest has already fed into the conception of and definition of the doctrine. It's inextricably bound up in the definition of the sorts of acts that it would cover. The conduct of military operations abroad, whether or not one should subject, for example, detention or lethal force also, to the vicissitudes of local law. And for those who weren't party to the earlier argument on Foreign Act of State or on Sardar Mohammed, the arguments I've focused on are related to detention, but they would equally apply to lethal force. Should a claim for damages be allowed to run in the context of someone who says, well, I was shot and that was a tort? And if that is so, then exactly the same problem arises, because that act would not be judged by reference to the standards imposed by international law. It would be subjected, if Mr. Justice Leggett is right about Afghan law, to the vicissitudes of local Afghan law. And under local Afghan law, you can only use force in self-defence. So when you are directly threatened, which would fundamentally undermine the ability to prosecute the sort of military operations that were underway in Afghanistan and Iraq. So the second answer is that the public interest is already fed into the conception of the doctrine, and you don't need to add that additional limb, particularly not a limb which focuses on the vice or otherwise of the specific local law in question. Thirdly, there is no support whatever in any of the case law to indicate that that sort of conception or control as a matter of that sort of species of public interest is critical to or an essential part of the doctrine. Fourthly, or perhaps an aspect of the...
Sorry, I missed that point.
Sorry, there's no support in any of the cases
Yeah.
for the Court of Appeal's conception of public policy focusing on a vice or otherwise in local law. Fourthly, or perhaps 3A, the analogies that are relied upon by the Court of Appeal in this part of its judgment to support the imposition of the new test, we respectfully submit, don't do so. And they particularly relied upon Conway and Rimmer. Now, Conway and Rimmer, as you will be well aware, did indeed introduce a rule under which the ipse dixit of the executive was replaced with a more nuanced balancing of the public interest. But that was a fundamentally different context, and here in the context of Crown Act of State, the courts themselves have already developed the principles and the control over the species of acts which will operate to create that defence of Crown Act of State. And they will continue to be involved in all the ways we have discussed.
Which paragraph of the Court of Appeal judgment do they refer to?
359.
Yeah.
Is that Conway and Rimmer, the 359 reference? I'm very grateful.
Thank you.
Yeah.
I mean, they divided it up into two parts. Firstly, they took a general view about detention, and they said, well, this isn't anything which is non-justiciable. That seems to take a rather narrow view of non-justiciability. One might say that detention was part of the war effort, which is what I think you would say.
Yes.
And then dealing with the tort claim, they dealt with it in the way you've just described. But they also went on to look at the specific cases and to point out that in their view, in Sardar Mohammed, the evidence showed that, and I remember we looked at this, he was detained not for security reasons necessarily, but more because it was thought he might provide significant new intelligence and so on. Are we going to go into the facts at all on this issue?
I'm not sure we are. I'm not sure we need to, because the argument at this stage is, should you be judging it by reference to those standards, which are fundamentally the kind of Article 5 standards and the international legal standards that we've been having the debate about in the earlier cases, as compared to, should it be local law or should it be those standards?
Yes, I see.
So I don't think we do need to get into that. And that was perhaps the fourth or the fifth point, which is that they do rely on more generally in part of their analysis, on human rights and the development in parallel and all of that. line of reasoning, which in the negligence context you considered recently in Michael, effectively saying they don't necessarily need to develop in parallel together. But the more fundamental point, apart from no need to develop in parallel, we don't for a moment dissent from propositions such as the common law is not an ossuary, or that you can't develop a common law right even though one doesn't exist under the HRA, Kennedy, those sorts of cases. Nor do we dissent from, indeed we positively rely upon the Michael line of reasoning that says you can perfectly happily have two systems going along that don't exactly equate, and just because the HRA and the negligence context has moved ahead in the context of police negligence or something equivalent, you don't necessarily need the same place or get to the same place under the common law. And so all of those arguments already exist, but the fact is that human rights in this context, we respectfully submit, really doesn't provide any sort of answer, for the very simple reason that, as we've just discussed, if you get into HRA analysis, as you may well have to, that posits a whole bunch of questions that Parliament has decided are appropriate to be posed and for the court to determine. Have you got power under Article 5? How does Article 5.4 work? All those arguments, many of which are referenced back to international legal standards. And the choice is effectively between that statutorily mandated system on the one hand, and on the other hand, a system that says, no, forget about all of that, or even if we've succeeded on all of that, Lord Wilson's point, circle back, or perhaps start from the position that it's all a matter of Afghan law, and Afghan law says 72 hours, he wasn't released after 72 hours, and Afghan law says only fire in self-defence, and this was a proactive military operation. So we respectfully submit that those arguments that are said, all of them, and again there may be quite a disconnect between some of the strands of reasoning and where they actually ended up, which was to say it's a public policy that we require, which is focused on identifying, very much as 14.3 would currently allow you to do anyway, focus on whether or not the local law in question has a particular vice about it. That's really where the Court of Appeal ended up, and we respectfully say that that's the wrong place to end up in principle. That's the wrong focus for all of the reasons that I've indicated. But in any event, and this is an alternative submission which is, as it were, related to the facts of our context, if not of our cases, if there is some form of public interest test which applies, which is focused on local law, the relevant public policy question should be, we submit, not is there a vice in the local law specifically, but is it appropriate to submit these sorts of acts to the particular demands of local law anyway? Now, whether you look at that as a general question or whether you look at it as a question which is related directly to Afghan law or Iraqi law, the answer is the same. Take Afghan law as the example.
Well, you could put it in pretty well the language of Section 14.3a of PILA, can you not? Which simply asks whether the application of the foreign law for determining any issue would conflict with principles of public policy. The relevant principle of public policy being, you submit, Act of State doctrine.
That's the alternative submission. We respectfully submit that the focus anyway should be on not identifying a vice in local law generally, specifically, but on whether or not this species of act should be subject to local law in any event. But that, my Lord, I'm entirely content for it to be put in that way, but we respectfully submit that the question is a general one. This is an in limine principle if it operates at all. It means that the court doesn't have to get sucked into the content of local law, whether it's appropriate or not appropriate. It's just simply irrelevant.
Well, if you look at the way they dealt with Mohammed's case at 361 to 364, having asked themselves the question, which you say is the wrong question, never mind, supposing for the moment it's the right question, having asked themselves the question, are there compelling considerations of public policy requiring us to deny this claim in tort? The answer, I think I'm right in saying, is no, because the detention policy which was operated was not justified by Afghan law. There isn't another one, is there?
No. I think that's right, and that therefore begs the question. We respectfully submit that Afghan law shouldn't be anywhere near this. If it was near this, the relevant question would be, the relevant analysis should surely be, whether one does it under Section 14 or one does it more generally, the relevant question should be, is it appropriate in circumstances where the government has considered what policy should apply to the detention of these individuals, or of individuals who are picked up on the battlefield in Afghanistan, what policy should apply? Answer, we look to the UNSCR, imperative grounds of security, we take into account the conditions that exist, we decide as a matter of deliberate policy that it should be for longer than 72 hours, or whatever the period is under Afghan law, for all sorts of jolly good reasons, and in those circumstances it is appropriate for Afghan law simply to be dragged back in. And
the only other factor that they do mention is in 361 Little Roman 4, where they point out that it would always have been possible to legislate. And indeed, I think the Americans probably did, didn't they?
Yes, I think they did. I think we explored that last time.
Yes, I think you told us that last time.
Yeah.
The Americans had legislated for special rules for their troops operating abroad.
I think that's right, and I think,
whereas we haven't.
yes, and I think Mr. Hermer placed some reliance on that last time. And said
Yes,
it was all,
I think he did.
by and large, tough appeared to be the answer because you didn't do the right thing legislatively.
Somewhat circular. I mean, maybe you didn't need to legislate, is your answer.
Yes, well, that was the answer I think I gave last time. Because we have perfectly decent authority under the UNSCR.
Well, we're deciding.
For this purpose. But the fundamental question about the facts is, even if you've got a public policy conception that says focus on the local law, it doesn't matter what answer you give. If you give the answer at the high level of generality, you say it's utterly inappropriate in an armed conflict, military operations governed by UNSCRs of this kind, to say you can only detain or fire your gun in circumstances where the local law, which may be and is utterly unsuitable, allows you to do so. Or you say, let's focus more specifically on Afghan law, and the point is made for me. Because the unsuitability is rife and obvious. You cannot possibly have a situation where, on their conception of it, the damages flow as long only as Sardar Mohammed is kept for longer than 72 hours.
To be fair, if you look at 364, fourth line, I think the Court of Appeal's analysis goes a bit further than, well, the law of Afghanistan didn't authorise this. It refers to the UN, it's already dealt with authorisation there being no authorisation to the UK, and no authorisation under the law of Afghanistan or under UK legislation. So they were looking around the world and finding no authorisation.
They were, and I'm not going to repeat the submissions I made in another context about the lawfulness under at least some of those systems of law.
Yes, quite.
So it slightly kind of begs that question, because we've had that debate around whether or not you have power under UNSC,
Yes.
whether you have power under IHL and so on.
International law, yes.
And there may be yardsticks, but all of those, the question here is not, it can't turn on this, because fundamentally the question is, should this be fundamentally dependent upon the ability to satisfy the conditions of Afghan law? That's the argument. That's why the private law claim is interesting for them. Because they can just say it's 72 hours, gov. That's the end of that.
Yes.
I'm not going to open up a great big can of worms, but you will. You might at least wish to note that, at least in the context of Afghanistan, there was, and I think I'm going to give you the reference without more, but there was, and it's in the Sardar Appendix number 2, I think we referred to it last time, but there was a military technical agreement entered into by the ISAF with the government of Afghanistan, which conferred at the level of the international plane. It was effectively an agreement between Afghanistan and the ISAF forces that there should be immunity.
Should we just have the reference on?
Yes, it's Sirdar Appendix Part 2, MS, and these are the MS numbers in the Sirdar numbering, I'm afraid, but 6404.
Thank you.
The provisions of the Convention on Privileges and Immunities of the UN concerning experts on a mission will apply mutatis mutandis to the ISAF and supporting personnel, including associated liaison personnel, and then various other provisions dealing with that. So at the level of the agreement between, I'm only referring to it because it to some extent reinforces the point about this being something which is governed and remediable, if at all, at the level of diplomacy in the international sphere, and that's the appropriate place to put it. And again, it prompts the question, well, how on earth does this not feature as part of Afghan domestic law? But again, without getting too sucked into the detail of it, Mr. Justice Leggett said, well, it doesn't matter what agreement was entered into in that respect between ISAF and the government of Afghanistan, because the law of Afghanistan as he conceived it did not make this international agreement part of domestic Afghan law. Might be thought that's a jolly good reason for the approach that we espouse. But what it illustrates is that even if, because of some vicissitude, another vicissitude of local law, the agreement that its own government entered into, effectively conferring immunity, didn't operate to have that effect, but it all rather illustrates that it's international plain or nothing in this sort of context. So, my lords, that's what we say in relation to Crown Act of State and its conception. I'm going to say nothing in opening about the Crown Proceedings Act, beyond, if I may, to give you very quickly the references to where you will find that analysis. And the reason I'm not going to open it is because we respectfully submit that Mr. Justice Leggett was right and the Court of Appeal, which effectively directly and in terms agreed with his reasoning, was also right on that aspect of it. Mr. Justice Leggett dealt with that matter in the Ramatullah judgment at paragraphs 210 to 215, MS numbering 8136 to 8138, and the Court of Appeal, agreeing with him, dealt with that aspect of it at 342 to 345 of their judgment. And for good measure, we've dealt with it in our case, if and to the extent that adds much, if anything, at paragraphs 120 to 132.
Does it depend entirely on that subsection fitting in the odd one, the bludgeon?
The bludgeon to kill a fly, the Glanville-Williams bludgeon to kill a fly.
Does it depend entirely on that argument?
It depends a bit on that. That's one of the strands. I think there were 3 or 4 strands.
That's all right. Okay. Well, because that's arguments, that strand has been criticised.
Yeah.
Anyway,
but I think the reasoning goes a bit beyond.
Yes. Right.
Article 6, can I deal with that very briefly in the 10 or 15 minutes that remain? Again, some of you heard more than enough argument, an extensive argument on this in the Foreign Act of State argument that we had, and I'm not going to go over all of that again. You know the nature of the argument. It's in 2 stages. The first stage says Article 6.1 is not concerned with the content or scope of domestic legal rights. You have Lord Hoffman in Matthews explaining how that theory all works and what its grounding in principle is. I'm not going to invite you to turn him up again, but the reference for your note is Lord Hoffman at paragraphs 28 to 29 in Matthews, which is in Bundle 4, tab 32, and those paragraphs are MS page 10,456. Effectively, he's saying there's all the difference in the world between a principle under which some issues are declared to be non-justiciable or out with the court's jurisdiction, on the one hand, and on the other hand, some discretionary power under which the executive, I think easily put it, can swoop down and shut down litigation. And the fundamental difference between the two is the difference between the rule of law operating and not. But that doesn't touch the question of what issues should be subject to what level of scrutiny by the domestic courts. And that, we respectfully submit, very much chimes with the way in which the Strasbourg court has gone about looking at these issues of engagement of Article 6. The leading authorities for this purpose, there are two. The first of them, establishing the broad proposition, is Z in the United Kingdom, which was the children in care case following on from Osman and the wrong turn that Strasbourg had took in Osman. And the relevant paragraph in Z in the UK is paragraph 98. Not going to take you to it now. Z is at bundle 7, tab 58. Paragraph 98 is at page 11510 in the MS numbering. And what the court said, I'll read it without you having to go to it, Article 6 does not in itself guarantee, said the court, any particular content for civil rights and obligations in national law, but then went on to say it is not enough to bring Article 6.1 into play, and this chimes with the description of act of state as reflecting something akin to an immunity in Shergill. The Strasbourg court in Z said, before Shergill, it's not enough to bring Article 6.1 into play that the non-existence of a cause of action under domestic law may be described as having the same effect as an immunity, in the sense of not enabling the applicant to sue for a given category of harm. So we respectfully submit there's a direct chime there, both with the reasoning of Lord Hoffman in Matthews and the reasoning of this court in Shergill. And the other case of some real interest here on engagement is Markovic and Italy. And again, I'm rather in the court's hands as to the extent to which you want me to go back to that. But Markovic in Italy was Bankovic translated into a civil suit against the Italian government in the Italian government's courts. And it was, in effect, struck out by the Court of Cassation in Italy on the grounds that the courts had no jurisdiction under their local law to deal with it. And so it sits, as it were, as an example of act of state, and I include that within that generally foreign act of state and crown act of state or something like it. I know that recently in the, just to go on a bit of a diversion, recently in the foreign act of state cases, there have been exchanges with the court about comparative law under German law and under French law and under Dutch law, and we've put in, I think the other side haven't yet put in their responsive submissions on that, but you've seen what we've had to say about that. I'm not going to get sucked into that debate, nor indeed would I be capable of doing so at this remove, because of the thoroughgoing complexity. You've seen effectively what we said, which is the Germans reach the same endpoint by slightly different routes, and the French are for us. But Markovic, at least, can be seen as a species, or as an indication of that which is relevant in that comparative area. What it demonstrates is the Italian courts shutting out that sort of claim on a jurisdictional ground, effectively that this is a political act. In other words, Italy becoming involved in the bombing of the television station in Belgrade. So it was, said Italy, see para 78 of Markovic, a dispute that wasn't of a type that could be brought before the courts of Italy because it was a political act. And so, as a matter of jurisdiction, the thing was shut down in limine, as out with the jurisdiction of the Italian courts on that basis. So looks and smells very like that sort of act of state doctrine working its way through the Italian courts. That's, as it were, by way of sidewind and comparative jurisprudence on the sort of point that the court's been thinking about in foreign act of state anyway. But for the present purpose, the relevance of Markovic is how is that sort of shutdown of that sort of claim properly to be characterised? Is it a matter of substantive local law and therefore out with the reach of the procedural protections in Article 6? Or is it properly to be characterised as a procedural bar and therefore subject to justification under Article the equivalent of Article 6.2 if it had that sort of doctrine within it. In other words, does it have to be justified as necessary and proportionate? Answer, said the Strasbourg courts, that is properly to be characterised as shaping the nature and content of the substantive right under local law, even though it was a jurisdictional quasi-immunity, if you will.
And the Corte di Cassazione, which had said that, and they said that that wasn't sufficiently strange for them not to accept it in Strasbourg.
Yes. Yes. But what that does is to open the door for the application of ground of state and it to work in the same way. It gives one a guidance, if not direct, because I accept that's the way they reasoned it, but it provides you a guidance as to what the answer would be likely to be, were you to be before me, as it were, on the application of this principle, which is obviously the premise on which one gets to Article 6. I only get to have to think about Article 6 if you're otherwise with me. But we respectfully submit that was the helpful reasoning of the Strasbourg court, and you'll remember that last time I took you specifically not merely to the way that the majority of the court had reasoned it, but also to the concurring opinion of Sir Nicholas Bratzer and Judge Rozakis. The relevant paragraph for that purpose is, you will find at 0, it's a bit confusing the numbering, but I think it's 0 capital Roman 2, 7 on MS page 11464 of the report in our version. Oh, sorry, it's 11466 rather than 464. So 11466, paragraph 0, Roman 2, 7. But in any event, we submit that even if Article 6 is engaged, the principle of Crown Act of State, as we've recommended it to the court, is justified. It pursues the legitimate aim identified by Mr. Justice Leggett on all the justifications that we've advanced before you, and it is a proportionate measure. It's only as wide as is necessary for the purpose that it is designed to serve, and it doesn't, at this point, all the one-voice undercutting that the Court of Appeal relied upon returns to operate in my favour, because the fact that judicial review might be capable of operating to provide restraint, the fact that HRA claims are not excluded by the doctrine, all of that serves to narrow the effect of the doctrine to allow scope for the rule of law to operate, and indeed specifically for human rights causes of action to have their fair play in domestic law. So we respectfully submit that if we reach the stage of justification, which we don't, this sort of measure is plainly justified.
You know that clock's about 7 minutes fast.
Yeah, well, those are my submissions 7 minutes early then.
14 minutes early.
14 minutes early. Well, it may be that my other friend wants to start
12
tomorrow morning,
minutes
but, or you want her to start now, but those are submissions I make in opening.
Thank you very much indeed. Ms. Stain? Ms. Kaufman, Mr. Hammer, you're happy to start?
Well, my lord, if I can just indicate the way you divided this up.
Of course.
Which is effectively that I'm going to run the arguments in Crown Act statement. I'm going to dig into their application to Mr. Mohammed's case. Unless your lordships would want to start now, I would prefer to start tomorrow morning, because there has been a tremendous amount of movement on the part of the Secretary of State today, which is going to have implications for how I put my case tomorrow.
Very well, that seems entirely... Make no comment about your reasons, but we will accede to your suggestion. We'll resume again at 10:30 tomorrow morning. Thank you very much. Court's now adjourned.